Hi, my name is Dr. Amy. For this presentation, I will examine the extent to which Malaysian mental health law strikes an appropriate balance between the individual autonomy and the need for state intervention. Mental health law presents a particularly difficult legal tension. On one hand, individuals should ordinarily have the right to make decisions about their own bodies, treatment, and liberty. On the other hand, there are circumstances where severe mental illness or an acute crisis may create serious risk to the individual or the others, potentially justifying state intervention. So I will examine this tension primarily through the Mental Health Act 2001 as amended in 2023, together with the Mental Health Regulation 2010 before considering Malaysia's position against international human rights standards, particularly the CRPD. Ultimately, I argue that Malaysia has achieved a necessary but only partially satisfactory balance between these two competing interests. Autonomy versus state intervention. Where should the law draw the line? This central tension can be understood as a conflict between two legitimate objectives. Autonomy protects liberty, dignity, self determination, and the individual's right to participate in decision concerning treatment. In mental health care, this becomes particularly important because a diagnosis for mental disorder should not automatically mean that a person loses the ability to make decisions. On the other side is the state intervention. The state has a legitimate interest in protecting life and health, preventing serious harm and providing care during the acute mental health crisis. There may also be circumstances where protection of the public becomes relevant. The difficulty, therefore, is not deciding whether autonomy or protection is more important in absolute terms. The real legal question is when does legitimate protection becomes unjustified paternalism? So that question will guide my presentation throughout will guide my analysis throughout this presentation. Before we go any further, we should examine our Malaysia's mental health legal framework. Our Malaysia's framework is primarily governed by the Mental Health Act in 2001, supported operationally by the Mental Health Regulation in 2010. The framework addresses both voluntary and voluntary admission, detention and treatment, consent, community mental health care, and patient safeguard. The Mental Health Amendment Act in 2023 is particularly important because it expanded the framework for intervention during the suicide-related mental health crisis. The domestic framework should be considered alongside the Persons with the Disabilities Act 2008 and Malaysia's international obligations under the Convention of the Rights of Persons with Disability or CRPD. So, Malaysian law already contains both sides of the equation, powers permitting the protective intervention and mechanism intended to protect individual rights. So the question is whether those protections are strong enough to counterbalance the coercive powers provided by the law. Analytical framework. To evaluate whether Malaysia has strikes an appropriate balance, I will use this proportionally based analytical framework. First, intervention must pursue a legitimate aim, such as protecting life, health, or others. Second, the intervention must be suitable to achieve that aim. Third, we should ask whether the coercion is genuinely necessary or whether a less restrictive alternative could achieve the same objective. Fourth is a proportionality. Does the protective benefit justify the degree of interference with the autonomy and liberty? Finally, safeguard matters. The greater the coercive power exercised by the state, the stronger the procedural and the independent safeguard should be. So I will apply these ideas when examining the detention, treatment, and crisis intervention. For involuntary admission and admission, this represent perhaps the clearest collision between autonomy and state protection. Under Section 10 of the Mental Health Act, an application may be made by a relative and supported by a recent medical recommendation. Admission may occur where the person's mental disorder warrant assessment or treatment, or where detention is considered necessary for the person's health or safety or for the protection of others. The Act does contain safeguards. A fresh examination must occur within 24 hours, and importantly, the practitioner responsible or the recommendation or admission cannot conduct that subsequent review. However, involuntary detention remains an extremely significant exercise of state power because the person's liberty is removed without consent. Therefore, merely satisfying the statutory criteria should not end the analysis. We should also ask whether the risk is sufficiently serious, whether detention is genuinely necessary, and whether less restrictive alternatives have been properly considered. My position is therefore that involuntary detention can be legitimate, but it should remain exceptional and proportionate, rather than becoming the default response to mental disorder. Crisis 2023 Crisis Intervention Reform. The 2023 reform illustrates that the autonomy protection tension particularly clearly. On positive side, the reform accompanied Malaysia's movement away from treating attempted suicide primarily as a criminal matter and towards a healthcare and crisis intervention response. From a right perspective, this is significant. A person experiencing a suicidal crisis should ideally receive treatment rather than punishment. However, the reform simultaneously expand the state's coercive capacity. Designated intervention officers may apprehend a person attempting suicide, enter premises where necessary, and bring that individual for psychiatric evaluation. The person must be brought for examination as soon as practicable and within 24 hours. So this reform is simultaneously right enhancing and power expanding. The protective objective is compelling because life may be genuinely be at immediate risk. Nevertheless, the broad emergency power should be accompanied by the clear requirements of necessity, proper documentation, training, and accountability. A human objective does not by itself remove the need for safeguard. Consent to treatment. Consent raises an even more direct questions about the autonomy. Section 77 provides specific consent safeguards for interventions such as surgery, electroconvulsive therapy, and clinical trial. Where the patient has capacity, the patient's own consent is required. The Act also provides a capacity assessment focusing on whether the patient can understand the condition, the proposed treatment, its risk, and available alternative. This is important because it shows that Malaysia law already recognizes the concept of individual decision-making capacity. The difficulty arises from the Section 77, subsection 4, under which consent is not required for other forms of conventional treatment. This creates a tension within the Act itself. If capacity is important enough to determine whether a person can consent to a certain serious intervention, why should capacity-based protection not apply more consistently to treatment decision? In my view, the preferable approach is that mental disorder should not automatically displace autonomy. The focus should increasingly be upon the individual's actual capacity, supported decision-making, necessity, and the circumstances of the treatment. Patients' right and safeguard. The existence of coercive powers makes safeguards especially important. Malaysian law does provide a number of protections. Section 78 of the Mental Health requires information to be provided to detained persons. Detention is subject to medical re-examination and statutory review, while the Board of Visitors provides institutional oversight. The mental health regulation also regulates restrictive practices such as restraint and seclusion. These safeguards demonstrate that Malaysia framework does not simply grant unrestricted power to the healthcare professional or the state. However, the existence of a safeguard does not necessarily establish its effectiveness. The more important questions are whether the safeguard is independent, accessible, and practically capable of challenging the unjustified restriction of liberty or autonomy. So this leads to my next slide of Board of Visitors. The Board of Visitors is an important statutory safeguard because it recognizes that coercive psychiatric powers require scrutiny beyond the treating clinical team. The board performs inspection functions and has a role of reviewing involuntary detention. However, the critical issue is the scope and independence of that oversight. Arumugam and her co-authors identified the absence of a comprehensive independent supervisory body overseeing Malaysia's mental health system. The board's role is therefore important, but institutionally narrower than that of a system with independent regulator. Judicial supervision may provide another avenue of legal accountability, but litigation is generally reactive and may not substitute for routine, specialized, and accessible oversight within the mental health care system. Therefore, my concern is not Malaysia has no safeguard, it clearly does. My concern is whether those safeguards have sufficient independence, reach, and practical effectiveness to match the seriousness of the cohesive powers they supervise. Independent of the sites, Malaysia and Ireland. So Ireland provides a useful comparator, not because Malaysia should simply transplant another country system, but because it illustrates a different model of independent oversight. So Malaysia relies significantly upon the Board of Visitors and other existing mechanisms. Ireland, by comparison, has an independent mental health commission together with the mental health tribunals reviewing the involuntary detention. Its framework also incorporates independent psychiatric examination, legal aid mechanisms, and inspection of approved centres and restrictive practices. The comparative lesson is therefore institutional. If the state exercises substantial powers to detain and treat individuals without their consent, legitimate legitimacy is strengthened where review is genuinely independent of the institution exercising those powers. I'm not suggesting Malaysia must reproduce Irish model exactly. Rather, Ireland demonstrates that stronger independent oversight is structurally possible and provides one model from which Malaysia could follow. Malaysia and the CRPD. The balance must also be assessed against the international human rights standard, particularly the CRPD. Three provisions are especially relevant. The Article 12 concerns equal recognition before the law and emphasizes legal capacity together with appropriate support in exercising that capacity. Article 14 protects liberty and security and rejects deprivation of liberty simply on the basis of disability, and Article 17 protects the physical and mental integrity of persons with disability. Collectively, these provisions challenge the traditional approaches in which a diagnosis of mental disorder itself becomes sufficient justification for substitute decision making or coercion. The CRPD therefore pushes mental health away from purely protection-based paternalism and towards equality, individual capacity, and supported decision-making. This does not make the practical problem of the serious mental health crisis disappear, but it does require stronger justification whenever autonomy or liberty is restricted. In other words, autonomy should not disappear merely because a person has a psychosocial disability. Right. So back to our core question: does Malaysia strike the right balance? Having examined the framework, there are credible arguments on both sides in favor of the current balance. Acute mental health crisis can create genuine and sometimes immediate risk to life, health, or the others. The Mental Health Act does contain medical and statutory safeguards, and the 2022 reform represents a significant movement away from punishment and towards healthcare in responding to attempted suicide. It would therefore be unrealistic to argue that coercive intervention can never be justified. However, there are equally significant concerns. Involuntary detention removes liberty. Section 77, subsection 4 permits conventional treatment without consent. Capacity-based protection is not consistently applied across treatment decisions. The 2023 reform expand emergency intervention powers while independent oversight remains comparatively limited. This feature also creates tension with the autonomy-oriented principles reflected in the CRPD. Therefore, I will not characterize Malaysia's framework as either wholly paternalistic or fully autonomy-based. It occupies a position between two, and in my view, the balance currently remains in. So my position is therefore that Malaysia achieved a necessary but only partially satisfactory balance. First, I will retain emergency intervention where there is a genuine and serious risk that cannot adequately be addressed through less restrictive measures. Second, autonomy should be strengthened through more consistent capacity assessment, supported decision making, and meaningful consideration of less restrictive activities. Third, accountability should be strengthened through more independent review of attention, treatment, and coercive practices. The objective should not be mental health system in which intervention is impossible. Rather, it should be a system in which coercion is exceptional, justified, proportionate, and independently scrutinized. This approach, in my view, better reconciles the state protective responsibility within the individual's anatomy and dignity. A more rights-based Malaysian model. From that position, I propose four areas for reform. First, capacity and consent. Individualized capacity assessment should extend beyond the limited categories currently protected by Section 77, together with the greater use of supported decision-making. Second, Malaysia should further prioritize least restrictive care. Voluntary, community-based, and other less restrictive alternatives should be properly considered before coercive institutional intervention where clinically appropriate. Third, independent review should be strengthened. Malaysia should consider developing a more comprehensive independent mental health oversight mechanism, drawing lessons from jurisdictions such as Ireland while adapting the model to Malaysian circumstances. Finally, crisis intervention must be accompanied by accountability. Emergency powers may be necessary, but they should operate alongside appropriate documentation, review, training, and information concerning patients' rights. This reform will not present this reform will not prevent intervention where it is genuinely necessary. Instead, they would narrow the unnecessary coercion, strengthen the individual's voice, and ensure that accountability increases in proportion to the power exercised by the state. So, in conclusion, Malaysians mental health law faces an inherently difficult task, protecting the individuals during the serious mental health crisis while simultaneously respecting autonomy, dignity, and liberty. My analysis suggests that Malaysia's current balance is necessary in principle but incomplete in protection. Protective intervention can be legitimate where serious and immediate risks genuinely require it. However, mental disorder should not self-displace legal capacity, consent, or individualized decision making. The greater the coercive power exercised by the state, the stronger the justification and safeguard should be. Malaysia, therefore, does not need to choose absolutely between autonomy and protection. The more appropriate balance is protection exercised through the right respecting law, where coercion is exceptional, necessary, and proportionate, where individual capacity and less restrictive alternatives are properly considered, and where coercive decisions are subject to a meaningful independent scrutiny. So in my view, strengthening those safeguards will allow Malaysians mental health law to protect vulnerable individuals without unnecessarily sacrificing the autonomy and dignity that the law should equally protect. Thank you.